Item 10. Miley, did you have anything to say about this?
Yes.
I'd like County Council to,
Oh, I'm sorry.
on item 10, I'd like County Council to explain why this item cannot be put over. And if it can't be put over, I'd like for us to have a sunset clause associated with this item. Because I think at the Transportation Planning Committee, what we're interested in doing is trying to address the commercial cultivation. We weren't trying to penalize individuals who are cultivating marijuana within the regulations of state law as it presently exists. And if we enact this ordinance is going to prohibit folks who are individually growing marijuana as for medicinal purposes to be able to they're going to be in violation in 30 days. And I don't think that, I know that wasn't my intent. So I'm looking to either have us put this over, and if we can't put it over, to have a sunset so that this ordinance goes out of existence once the state takes measures to enact a change to its regulation.
Okay, so this item is brought before your board at the direction of the Transportation and Planning Committee after we did a presentation on new legislation that was adopted and signed into law by the governor approximately around the beginning of November of last year. That new legislation put into effect rules where the state created a regulatory scheme for dealing with the cultivation of dealing with the cultivation of marijuana. It filled in a void that didn't exist, or it filled in a gap that was there with respect to things that the Compassionate Use Act and the Medical Marijuana Program Act did not adequately address. So now the state has, part of that regulation is that the state has said that it will be developing a more specific regulatory scheme to address cultivation. It will be taking certain actions and licensing or regulating cultivation activity. And there's language in those provisions that indicate that if local jurisdictions would like to regulate in that space, they would need to have laws regulating or prohibiting the cultivation in that space on the books by March 1st. Because of the nature of the way this body as a county makes rules, we are required to adopt that regulation by ordinance. And in order to adopt that ordinance, it takes 2 readings. So your board has 2 meetings, the meeting today and the meeting on the 26th. And in order to and then the ordinance, if you were to adopt an ordinance today and then have a second reading on the 26th, that ordinance would not become effective until 30 days after the 26th of January. So it doesn't leave you time based on your current meeting schedule to continue this item or not act on this item unless you schedule a series of special meetings and then have a regulation in place to meet that March 1st deadline. I know that there are people who have indicated that the March 1st deadline that was in the state laws was not the intent. Unfortunately, up and down the state, jurisdictions are relying on what they believe that the law says. And the rules of statutory interpretation, courts first look to what the plain meaning of what was enacted says before they go and look to see what other intent there was to give effect to those words. And in the communities that we're a part of, it's pretty consistently understood that the proper interpretation of that language, the language in the law, is that there is this March 1st deadline. So everyone has been talking about the legislature has said, oh, we didn't intend that, and we're going to fix it. And we understand that legislation is pending to try to fix that. We checked today to look at updates, both our office and the county administrator's office checked to see what the updates and the status of that legislation is. And it's not clear at this point that legislation will be adopted in time to meet that March 1st deadline. It may not be adopted, the fix may not be adopted by March 1st, let alone in time for you to take action if it doesn't go the way that we intend. We understand that there are a variety of different amendments that people are proposing, that the Urban County Caucus is looking at certain amendments, that the ACLU is looking at certain amendments. So that could bog down the fix that people expect to happen, such that it won't happen by March 1st. So the deadline, so what you have before you is a ban. And the reason that what you have before you is a ban is because your board committees have not had an opportunity to consider the issue responsibly and give direction to draft an alternative ordinance. And I think an example is what we've seen here today in terms of how these tobacco hearings have gone, these e-cigarette and the commentary regarding medical marijuana, that these are significant and complicated issues. So in order to, while your board had the option of regulating cultivation, that is probably not an ordinance that your board could give us adequate direction on and have us what that regulation might look like, in the next couple of days. And so the ban is purely intended to be a placeholder so that we have a regulation in place so that we meet the standard in the state statutes as those statutes currently exist. And then you will have an opportunity at a later date to come back and fix it when you have a regulatory scheme that you would actually like to adopt.
Can we, again, to Supervisor Miley's point, impose the sunset so that when AB 21 passes, ours would sunset?
Yes, you could adopt a sunset.
Add that to the ordinance?
Yes, you could do that.
So
And you could do that today.
And I want to respect the speakers, but give us a minute. How do we get at the issue, and maybe you said it and it got lost in all the legal stuff, but there's certain people that are currently growing for collectives or whatever.
And so I did not say that, and there are 2 points that I want to make about that. One, we don't currently permit growing in the unincorporated area, except to the extent that you could argue that growing is permitted by the Compassionate Use Act or the Medical Marijuana Program Act.
Which would trump any local ordinance. Anyway.
Which would trump any local ordinance. So to the extent that those laws already give people who are operating in conformity with those laws a get out of jail free card, they would still have that. Our local lawmaking couldn't override legislation that the state, well, actually that the voter initiative created and then subsequently the state created that authorized that growing. So if in fact that grow is permitted under state law currently, they would be protected from any criminal prosecution based on the immunities that exist in state law. But there could be grows that are not consistent with state law.
Those are illegal.
Yeah.
I mean, no matter what we do. But this doesn't stop those that are currently growing for collectives or whatever. This doesn't stop them from being able to do that.
All I'm willing to say is that if they are growing consistency, consistent with
Look, if somebody's got 700 acres of pot going out in Livermore right now, they're illegal no matter what, okay? Correct?
Likely,
unless they have a lot of names.
yeah.
Okay.
They'd have to have a primary caregiver
I think I'm
list.
clear. I don't think this stops those that are currently doing it, but certainly the public testimony will probably tell me I'm wrong. Can I go to the public testimony? Any other questions before we get started? Dale Garnier, I think it was. Ellen Camp, Sharif El Sasai. You're very busy today, sir.
Yes.
How come his mic's not on?
Yeah, and I was involved in some of the discussions about this MRSA Act, where all of this comes from. But this ordinance, as written, is an over-response that really impedes on individuals' and patients' rights to cultivate for their own personal use. What is at issue here under this state law that was erroneously passed, apparently, and is hanging out there waiting to be repealed, is simply the power of the county or the city to license medical cannabis cultivation for commercial purposes. Because there's going to be a new state licensing system that has not been implemented yet. And under that system, the license has to be granted both by the state and by the city or county. Under the law, what they said here when they wrote this law, and I will quote from the state law that's at issue. If a city, county, or city and county does not have land use regulations or ordinances regulating or prohibiting the cultivation of marijuana, then commencing March 1st, 2016, the division, that is to say this state law, shall be the sole licensing authority for medical cannabis cultivation applicants. So the only thing that Alameda County would lose if this, if they didn't act by March 1st, would be authority over applications for medical cannabis cultivation commercial permits. However, non-commercial activities are specifically exempted from state regulation. But the ordinance, as written here, covers all cultivation in the county, and that's a real problem to the many people who are already growing for personal
Ellen
use.
Camp, Sharif El Sasai, and Andrew Scher.
Hi. Yeah, to pick up where Dale left off, I think specifically what needs to change in this is at the bottom of page 3, section 6106040, where it says medical marijuana cultivation and delivery prohibited. It should say commercial cultivation, and also in number A, or item A and number 1 should say commercial if it's going to go this way. Under enforcement, you talk about item C says that patients cannot be going for themselves only, cannot be charged with any kind of misdemeanor crime, and that is true. And they should not be charged with any kind of civil fine either, nor should anyone have a misdemeanor fine over this. I know how these bans go and how enforcement go. It's going to end up impacting the low-hanging fruit, the guy who's just trying to grow a little bit in his backyard. Now he's going to be guilty of a crime until such time as maybe you can find time to regulate it. And I understand you're under the gun here. This is why they're rolling back this March 1st deadline, because there hasn't been time for anyone to regulate it instead of ban it. But it was never the intent. To me, it's sadly ironic that all the cities and counties have been calling for statewide regulation on this, and now that we have it, they're turning around and banning instead of working and waiting for the statewide system to work its way out. I brought, I guess I'll give to the clerk, she can give to you an analysis from NORML that says, we don't think that even if the March 1st deadline is not rolled back, that it's going to in any way impact permanently your ability to regulate. And you ought to be looking at how to regulate anyway and taxing it. New cleanup legislation 1575 on MRSA specifically clarifies that cities and counties can tax and issue fees over the state fees. So we need it in the light of regulation and recouping taxation. Thanks.
So go ahead, Donna. Maybe you're going to get it. Excuse, give me a second there. Sure.
So we would not support inserting the term commercial into the ban, because it would be our belief that your board would want to regulate grows that may not be medical marijuana permissive grows, and they also may not be commercial grows. They could be grows for some other purpose that aren't being done in a safe or responsible way. So by limiting yourself to only regulating commercial grows, you haven't captured all of the potential grows that might be out there. So that wouldn't be appropriate. And just with respect to the NORML letter, I did take a look at the NORML analysis. I found it utterly unpersuasive. I think it makes the point that we've been making. The NORML letter specifically says that it doesn't make, when you read the NORML letter, it's apparent that it's not clear when your board would be able to regulate. It says, well, it's not clear that the deadline is March 1st. It doesn't say you would never be able to regulate. It just doesn't tell you when you'd be able to regulate. So it doesn't clarify the issue, and the NORML doesn't argue that you would be allowed to regulate at some defined point in time, so that you're in the same position. It leaves you without the opportunity to regulate, and you're dependent on the state fix, and your hands are tied. This puts an ordinance in place that makes it clear that at some later date, when you've studied the issue and decided how you want to regulate cultivation, that you're free to do it.
Thank you. Sharif?
Good afternoon, Supervisors. My name is Sharif El-Sisi. I'm speaking on behalf on the Garden of Eden, one of the 2 dispensaries in unincorporated. In a time where medical cannabis is gaining ground, there was an epic failure in the form of a clerical error when the MMRSA was created. That error has allowed the movement to lose so much ground so quickly across the state, in cities, in counties. These bans, which are basically being stamped out, are popping up everywhere. Almost every city in the Bay Area is looking at this currently, literally this week, next week, and the week that just passed. And the county shouldn't have to rely on the state to correct its mistake to ensure its ability to license, tax, and regulate cultivation. I completely agree, and something does need to happen today. If there's no action taken today, there's nothing that ensures the state will act. And on the other hand, I don't think that the patients of Alameda County should have an overbearing ban on cultivation placed on them. I don't think that was your guys' intention in the last meeting, and I don't think that's what should happen here today. There are hundreds, if not thousands, of patients who have personal cultivation in their homes, and like was said earlier, that would become illegal 30 days after the passage. And I think the way that all involved parties, all stakeholders could agree to move forward would be to insert a sunset clause, and that sunset would occur when the state acts to remove the March 1st deadline. There is a Assembly Bill 21 sponsored by Bonta, which will be heard in committee tomorrow in Sacramento, and the talk is that there's nobody that's going to be opposing it. The other stakeholders, ACLU that she had mentioned, don't seem to have any intention of holding up the cleanup language. So Andrew Scher, an attorney that represents us, can maybe clarify some of the details of the sunset we intend to propose. Thank you.
Thank you, Andrew. Dress wedding, Jen Korea, I think.
Yes, Andrew Scher. As Sharif said, I'm here representing the Garden of Eden, and I'm also speaking in favor of adding a sunset provision if the ordinance is passed in any form. I'm also honored to represent a 73-year-old amputee woman in Fresno County named Diana Kirby, who is allergic to all pain medication and is simply fighting for her right to cultivate 6 marijuana plants or less in her own backyard. Her case is referred to specifically Diana Kirby v. County of Fresno. It's in the proposed ordinance. And yesterday, we, along with the ACLU, filed a petition for review of her case in the California Supreme Court. As the County Council's discussion of this proposed ordinance states, the primary intent of the ordinance is to preserve the county's authority to regulate and license medical marijuana cultivation by having a local ordinance regulating or prohibiting cultivation in place before March 1st. The sunset clause comports completely with the intent of the ordinance. If the intent of the ordinance is to be a placeholder, then state expressly in the ordinance that it is a placeholder by putting this sunset clause. There's no reason to have an ordinance in effect for any longer than absolutely necessary if that ordinance has not been thoroughly studied and may very well be preempted because it conflicts with the state law guarantee that medical marijuana patients have the right to cultivate 6 plants or less. In conclusion, I understand that the County Council is under pressure, but I think the sunset clause is a very prudent way to deal with those pressures and resolve this situation.
Dress wedding, Jen Korea, Jennifer Garcia.
Good afternoon, honored board. Once again, as a representative of over 200,000 medical cannabis patients, I implore you not to do a ban at this time. Many of those patients do cultivate on their own, and with the flux in what the law is, I see no reason to take such severe action at this time. In addition, delivery services to the unincorporated areas make this medicine available to many people who would not otherwise be able to get it easily. It severely impacts their quality of life. Thank you very much.
Thank you. Jen Correa, Jennifer Garcia, Kelly Quirk. So what happened to Jen? Jen, are you here?
Maybe, I think they're.
Well, you guys are, oh, you know what?
I have my name wrong.
Yeah, it might be.
Okay.
The one looks like Korea, though.
Okay.
Go ahead.
That's right. My name is Jennifer Garcia. I'm actually a business organizer representative for the UFCW Local 648. My local has recently been assigned organizing for the cannabis division. I'm here. The UFCW, United Fruit and Commercial Workers, is a worker-based organization, and we are here on behalf of current workers in the cannabis industry that we represent and future workers that we'd like to represent. Too many jurisdictions are moving to enact laws without fully considering the positive ramifications and opportunities for businesses to step out of the shadows. Again, everybody spoke about the intent of the March 31st deadline. They are addressing that at the legislation right now. I'd like to ask that the supervisors delay this proposed ban. A ban will decrease the general fund by foregoing revenues from licenses and sales tax. And I think the county should be proactively looking at ways to enact laws that allow medical cannabis commercial activity to look like other commercial activity. A prohibition could force businesses that are willing and able to move into a regulated business model to possibly go back underground. An underground economy is not good for the workers. An underground economy does not provide decent wages, health insurance, sick leave, paid vacation, and pension. An underground economy makes it easier for workers to be exploited and abused, and no recourse for the worker. So if done right, regulations can provide the opportunity for cannabis workers to gain stable jobs and standards for health and safety, which is important in this industry. The USCW, again, is concerned with current and future workers. We want businesses with high communities and worker standards, and we want good, sustainable jobs in our communities. Thank you.
Thank you, Kelly. Robert Wright, and then Alex Zavel.
Good afternoon once again. Kelly Quirk of Harborside Health Center in Oakland. I'm here to speak against the ordinance from two different perspectives. One is first related to the new state regulations. The second is about the people who would be harmed by this ordinance. And I also want to speak most specifically to the delivery language that's in the ordinance. While the preamble to the proposed ordinance does state that the county intends to later implement a revised ordinance to regulate and license medical cannabis, the fact that this proposed ordinance includes no target date or sunset clause, as other speakers have mentioned, raises the possibility that once enacted, inertia will set in and this quote-unquote temporary ordinance will stay in place much longer than intended. The other point with respect to the state law is that the state law contains, and the hurry that the board is taking in trying to implement some sort of regulations, the state law contains no deadline for regulating or prohibiting medical cannabis delivery. It's not mentioned. So there's no time-sensitive reason at this point to include even a temporary prohibition of delivery in the ordinance. And then to get to the people who would be harmed, the harm that prohibiting delivery and cultivation would inflict on homebound patients, the senior, elderly, people who are disabled, as well as people with other transport challenges in terms of traveling to dispensaries, which they would have to do in order to get their medicine, would allow no access to this remarkable and healing medicine. And I think on this basis alone, an enlightened county like Alameda should reject this ordinance. Thanks very much.
Thank you. Robert Wright. Robert, nice to see you. Been a while.
Thank you, Mr. Chair, members of the board. I am Robert Raich. I'd like to state first that the interpretation that is being advocated for the very reason for this proposed ordinance is faulty. It's been advocated by the League of Cities as a way to try to persuade local jurisdictions around the state to enact bans, quickly get bans in. We have the sky falling. There's this alleged March 1st deadline. The section in MRSA, the state law that deals with that, is section 11362.777C4. A reasonable reading of that language doesn't say that if you don't pass a ban by March 1st, that you will never be able to ban again. You'll never be able to regulate again. Clearly an interpretation which was reasonable and fits in with the entire body of the whole state law would allow a county or a city to enact further regulations or bans after March 1st. That deadline is only put in here just as a way to try to create some kind of urgency. That urgency doesn't exist. You still have the power afterwards. There are plenty of other provisions in this whole law that don't even deal with the health and safety code, that are in the business and professions code, not this section, but other sections of the law that clearly talk about how cities and counties will have authority to regulate, to give licenses. You can't even get the state license unless you have a local license or the equivalent. Further, this section of the law deals with applicants, people who are getting applicants, people who will be doing commercial activity. The local ordinance doesn't just concern commercial activity. This section specifically exempts individual patients and caregivers. The ordinance before you would not do so. Also, this section deals only with cultivation. Your ordinance before you would deal with deliveries as well. Who knows why that might be. There's no reason to even consider deliveries in this ordinance. Thank you.
Thank you. Alex Zavell. And then to me it looks like Orville Mean, but I'm sure that's not the truth. Maybe it is. Okay.
Howdy. I appreciate the opportunity to speak for you today on this matter. I work in cannabis-related legal issues with the law firm Robert A. Raich, PC, but I also hold a position as a local policy and regulatory expert and the chair of a subcommittee on that for the National Cannabis Bar Association. And I've been very closely tracking local approaches to the MMRSA across the state. And I think that what we have before us today is the hydrogen bomb option to respond to an issue which we have an overwhelming consensus is moot at this point. You know, I've been in close conversation with Assemblyperson Bonta's office. They are the lead author of this bill. It is on a rocket ship through the legislature. There has been some objection that was earlier registered by the ACLU. The intent is to address their issue. They're just trying to have something else they want addressed. That's going to be addressed in another bill. And there's no reason to think that this deadline will still be in effect or bind you. There's a letter from the author of the actual legislation that included the deadline initially, AB 243, that's Jim Wood. He intends to strike it. There's not going to be a movement in Sacramento to preclude you from implementing regulation that you deem appropriate for your communities. And this language will likely be struck before March 1st and even possibly before the end of this month. On the off slight chance that something goes sideways with that and it takes a little bit longer for it to be removed from the law, you're being asked to adopt a complete prohibition currently with zero phase out, zero sunset, which, as another speaker pointed out, could really put us in danger of developing an inertia behind this ban. And so I think that on that basis, I would, encourage, caution here. You are going to impose, actually, there's a lot of cost with taking this precipitous action now. It's way overdone, and it will cause damage for sure on the basis of a speculative, hypothetical, low-risk situation where this deadline stays in effect. So please use prudence. Thank you.
Thank you. That was our last speaker. I'll bring it back to the board for deliberation. And I'm sorry, Orville. Well, I don't have one. What's your name? Oh, okay. Orville, I apologize.
Oh, no problem.
And then Noah, you're next.
I'm not going to take up too much of your time. I brought the information to the board at the time to Supervisor Nate Miley about the issue of the state having to have regulations in place by March 1st of 2016. I didn't know it was going to be an overreaction. This is an overreaction for this board to even think that they need to ban. But at the same time, I do want to say this. If you ban, I don't think the state will allow you to go back from that ban. So don't ban because of that. because under the legal ramifications, and I'm no lawyer, but under the legal ramifications, the state probably would supersede at that point. What we're asking you to do here is to try to at least put a sunset clause or something in there to allow you to move forward, but do not ban. Banning would just be the worst thing at this time. That's all I have to say.
Thank you. Noah Pomerantz?
Thank you. I work with Harborside. I'm an attorney, and I'm a former public safety dispatcher with the Mountain View Police Department. I'd urge you not to support the proposed amendment as it's currently drafted. I have 2 quick points I want to make. As others have mentioned, the March 1st deadline is very likely to be repealed, but even if you can't bring yourself to fully trust the state legislature, I hope that you would at least put in a sunset clause indicating that the temporary ban you're considering today will expire when the March 1st deadline is removed by the state legislature. If your intent is just to have a placeholder simply to retain local jurisdiction, there's just no reason not to have a sunset clause. And the other point I want to make is about the prohibition on delivery. The March 1st deadline is purely about cultivation licensing. It has nothing to do with delivery at all. There is no time-sensitive reason to prohibit delivery. I attended the planning committee meeting last month, and I may be mistaken, but I believe that both supervisors present said that they were in favor of delivery in a general sense. And given that, and that there's no time-sensitive reason, I'd like you to really consider the harm that even temporarily banning delivery will do to patients who are homebound or seniors or otherwise have difficulty physically traveling to dispensaries. And I also have a letter from written on behalf of Law Enforcement Against Prohibition that was emailed to the board yesterday, but I'd like to leave it with the clerk in case you guys want to look at it. Thank you for your consideration.
Okay, thank you. That is the last speaker, so now I will bring it back to the board for deliberation and action.
Supervisor Haggerty, can I just give you 2 pieces of information so that your record is clear? One, with respect to the issue of the prohibition of delivery, your existing ordinance, the chapter 6.108 on medical marijuana, it does prohibit our dispensaries from delivering medical marijuana already. So, there is some prohibition on delivery in your current rules. With respect to the conflict with state law, there is language in this ban that is before you today that says this chapter shall be interpreted to be compatible and consistent with federal, state, and county enactments. So we tried to put some language in there to indicate that we are not that there isn't any intention to override activity that is permissible under the Compassionate Use Act and the Medical Marijuana Program Act.
It sounds like all we would need is a sunset date. Supervisor Miley?
Yes, thank you. Yeah, because by no means do I want to harm patients and caregivers. By no means whatsoever. And nor do I want to place in effect any measures that affect our present dispensaries in the unincorporated area. Because as small operators, I want to make sure that they can continue to provide the service that they're providing. And if our ordinance were to have any implications beyond the unincorporated community, I wouldn't want to affect dispensaries that are operating in Alameda County. I've heard stuff from attorneys who are representing the medical marijuana community, and I've heard county council. And I think the intention of the Transportation Planning Committee was a placeholder. I serve on that committee, and I can speak for myself for sure that my intention was a placeholder. In fact, my intent is to have, because I think we're having a Transportation Planning Committee meeting during this month. I think the meeting is set for January Eileen's not here, but 21st, January 21st. So we're having a Transportation Planning Committee meeting on January 21st, and I think at that meeting we'll be looking at our existing ordinance, and it's my hope that we're going to begin looking at amending our existing ordinance so that it can come into alignment with state regulations that will become applicable, so that anything that's allowed under the state will be allowed under our ordinance.
And the preamble does indicate that this is a placeholder. The preamble to this ordinance reflects that.
So at the Transportation Planning Committee, I think we're going to be taking up this matter and looking at it even much more in a much more robust fashion on January 21st. So in the interim, between now and March 1st, recognizing that this is a placeholder and recognizing that ultimately we don't want to do anything that's going to harm delivery of medicine to people in an unincorporated community, nor do we want to harm caregivers and patients. If we put a sunset clause in place and make that sunset clause March 1st, what impact will that have between now and March 1st on patients and caregivers?
I would recommend that if you do a sunset clause, you put it beyond March 1st, because you need to have the regulation in place as of March 1st. So I think you need to put it beyond in the event the legislature doesn't act by March 1st. That I think you need to give yourself a cushion. I think March 1st would be too soon of a sunset date.
What's the first board meeting in March? March 2nd?
I believe it's the 2nd.
March 2nd. So why don't we put the sunset as March 2nd and have this matter come back to the board on March 2nd to be revisited at that point in time?
March 3rd.
March 3rd is the board meeting? Because
I'm saying it could expire on March 2nd. There's time between expiring at 12:01 us meeting.
Oh, okay. But everyone keeps saying that they anticipate that the state's going to act on this prior to March 1st. So I would think that come March 2nd, we'll know.
I mean, well, as you know, we have to put an item on the agenda in order for your board to take an action.
Yeah, that's why
earlier than that. So if you have it sunset on March 1st, it may not give us adequate time to get an item on the agenda for your board to take up.
Well, you could put it on the board, and if it's viewpoint, we can just table it.
I'd recommend you give yourself a cushion, and at a minimum,
So,
move it
Supervisor
out
Miley,
to
I think something else. I think
move it out
that
to the next board meeting.
one of the things that the Transportation and Planning Committee needs to deal with is the actual land use too.
Yeah.
So we do need to give ourselves a bit of cushion so we can work towards the land use portion of it.
Okay. So
Well, if they fix it, it'll be moot.
Okay. So
And
why don't we make
it won't matter
the
if it expires, but if they don't fix it, it will require some action by your board.
Okay, so why don't we make the sunset effective, the enactment of the amendment or the enactment of AB 21? So when AB 21 becomes law.
So we'd recommend that it not be tied to the amendment of AB 21, but the elimination of the clause.
Why don't you just make it 2 weeks after the 2nd?
Yeah.
So I'm trying to understand what would work best, the elimination of the clause or a specific date and time?
Both. The specific date or
the elimination of the clause.
Right.
Whichever comes first.
Whichever comes first.
So we had, while we were sitting here, I drafted some proposed language that would automatically repeal the ordinance upon the adoption of state legislation repealing or eliminating the March 1st, 2016 deadline in Health and Safety Code 111-362.77C4, and as opposed to tying it to a particular bill, there might be other legislation that moves forward, although AB 21 appears to be the legislation going forward. You do always have the option of coming back and repealing the ordinance by a separate action as opposed to building it into this ordinance.
So if we adopt that language, what happens between now and the repeal of the ordinance?
Because
to caregivers and patients and folks who are delivering.
Because of the language that's in this ordinance that indicates that it is to be interpreted consistent with state law, and because, as I said previously, you don't have the ability to override the voter initiative that gave primary caregivers and patients the rights that it gave them. They continue to have the right to engage in the activity that's permitted under state law.
Okay, so our ordinance would not impact that.
Correct.
You need to hear what The other thing that was said, though, is that we do have a prohibition against delivery right now.
That's by our dispensaries, but
Yes,
people
by
are
our
receiving it
dispensaries.
out from other dispensaries into the unincorporated area. So that's happening, and our ordinance wouldn't affect that because we don't regulate dispensaries outside of our jurisdiction, right?
Well, it would
So that's true, and then there
Right.
is the provision in the MRSA that allows the use of the carriage over the public road, so
So-
we could not prohibit that regardless.
Okay, so I just want to be clear on this. So if we enact the language the county council has come up with that gets at the sunset, our ordinance will be repealed upon the triggering of that language. Secondly, patients and caregivers are protected under state law. And thirdly, deliveries that are existing, that are coming to patients in the unincorporated area will continue, but those deliveries are not being, operated under our jurisdiction through our dispensaries.
provided they're consistent with state law.
State
Yes.
law, okay. So will the clerk have to read the ordinance and then we'll make the amendment with the sunset? Is that
Yes.
how you will approach this?
Yes.
Okay,
Then you
so
can make
when the president's ready, we'll make
Do
the
you have any
amendment.
questions? Do you have any questions this way?
An ordinance of the Board of Supervisors of Alameda County adding Chapter 6.106 to the General Code relating to the prohibition of medical marijuana cultivation and delivery.
I'd like to move for the adoption of this ordinance with the amendment that we will have a sunset clause with the wording that County Council has articulated. Could you read that wording again?
Yes, this would be a new Section 2, renumbering the current Section 2 to Section 3. It would read that this ordinance shall be repealed upon the adoption of state legislation repealing or eliminating the March 1st, 2016 deadline in Health and Safety Code Section 11362.77 sub C sub 4.
Okay, so that's my motion with the move for adoption of the ordinance with that amendment. And I move for the balance of the reading of the rest of the ordinance.
Can I ask that we make a friendly amendment? We'd like to make this, the language that Ms. Weddle just read, to say that this ordinance will be repealed by its own terms. So it's clear that it's self-executing.
Oh,
And
it's
it would-
self-executing.
yeah.
Okay, all right. So the language as read into the record by County Council with that addition on its own terms.
So can we read it one more time with
Okay.
the
Can I
language as it
just
is?
let me stop for a minute? Okay, I have a motion and a second to move away the balance of the full first reading of the ordinance and move for its adoption with the inclusion of verbiage by County Council, which will now be read.
Section 2, that this ordinance shall be repealed by its own terms upon the adoption of state legislation repealing or eliminating the March 1, 2016 deadline in Health and Safety Code Section 11362.77 C4.
That's my motion.
All right, is there any objection to the motion? Motion passes 5 ayes. Thank you.